All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Good Saturday afternoon. Carl Rominger here. 540-0580, talk line number. Call in. We'll take your calls here on the air. I'll answer your legal questions. If you don't have a legal question, well, I guess you could call in and talk about something else. We could do Tradio. You could call in and we'll sell stuff, for you. 540-0580. The 11th Circuit ruled that a person does not need to give the password to decrypt their hard drives. There, the government had, as part of a child pornography investigation, and don't get tripped up on that. It doesn't matter what the investigation was about. It's a criminal investigation, whether it was for murder, tax evasion, or child pornography. It doesn't really matter. The court ordered the person to provide it. They held out, and the 11th Circuit Appellate Court said no. He had a Fifth Amendment right to remain silent, which extended to giving away the password, because if he accessed those hard drives for the government, he would therefore link himself to the content, or at least arguably link himself to the content, perhaps even beyond a reasonable doubt, because he knew how to access it. The government importantly conceded in the case, however, that while they believed there may have been offensive material on the disks, they couldn't say with certainty either, and the court found that to be somewhat relevant in the case, that in other words, this was a fishing expedition, and they were trying to force this guy to open up these hard drives so they could see whether there was anything on there or not. So the next time a police officer or somebody asks you, give the password to your iPhone or your other mobile device, you may not have to. So hopefully you're never in that situation, but the 11th Circuit Court of Appeals ruled on it. Now, some other courts have gone the other direction, but those cases are sometimes a little factually different. There's also a case involving United States Supreme Court involving tax returns that go back, and that was cited in the 11th Circuit case. So if you want to read it, I will put it up on my Facebook page, the actual opinion. I do have a link to an article on there. But I strongly recommend you take a look at that, because it's going to be increasingly important. Right now, you store all your life on your digital device, and I know you go, I have nothing to hide, so who cares? But the question is, you never know. You never know when the government might want to pry and make something else a crime that you would never think which should be a crime right now. Think about health care. Pretty soon you're going to have to be mandated to get health care, and it's going to be a crime if you don't sign up. And I'm sure half of the listeners out here would willfully disobey that law given the opportunity. 540-0580. Frank, you're on the air.
Yeah, Carl.
Hey, what's going on?
Well, my stepfather died, and he didn't have a will.
Did not have a will?
No.
Okay.
He has two natural daughters, and according to our lawyer, they get everything. Okay.
Right.
He had a bank account that I was joint owner in.
Okay.
Okay. Are they?
That should be yours. If you're the true joint owner, and it's joint ownership with the right of survivorship, it just passes to you automatically upon death.
Okay. Okay. That's what I was just wondering.
Yeah.
He had another checking account that didn't have no survivor or no joint owner or anything like that.
And that one just passes through the estate, which would be through the laws of intestacy. I assume that your mother predeceased him?
Yes.
Okay, yeah.
Yes. And when that happened, that was 10 years ago, he had already went and put the real estate in my name.
Uh-huh.
So they can't touch that either, right?
That's correct.
Okay. And as far as anything in the house, just his personal belongings?
Those are all individually owned by him, so they're going to go through the laws of intestacy.
Okay. So everything that was my mother's would stay with me?
Correct.
Okay.
Well, it depends. If your mother left stuff to, when she died, presumptively, if she didn't leave it to you, it went to him, right?
Correct, yes.
And so that's all his.
Oh, yeah. So that would be all theirs then.
Yeah. Yeah. Okay. Now, if they're decent people, maybe you guys can sort it out, but this is a good segue to remind people you can get that free will at weekendappointment.com or get your will updated. So if you don't have a will, this is exactly why it can be a problem, because you may not have been, your mother and or your stepfather may have not adequately done things the way they wanted to, because they simply didn't put it in a will and tell everybody what it is they really wanted to have happen.
Correct, yeah. the money that's in my name in the bank account.
Yep.
Should I just take it out right now? Or?
Well, I think you're the only one who has access to the account now. Once he passed away, it's your account. There will be a tax consequence to the estate for probably 1/2 the value of the money of the account unless it's been in there less than a year.
Yes, yeah, it's been in longer than a year.
So.
Yeah, okay. That's what I was just wondering because I contacted the bank and they like to close the account as soon as possible. And
yeah, I mean it's your money. You can do whatever you want with it.
Yeah, that's what I don't know if they could sue me to get that money.
No, not at all. The only question would be who has to bear the tax on the 1/2 at probably at 4.5%. No, you're not really his kids. It's going to be a 15% tax.
Okay, so that'd be the inheritance tax, and that's it.
Yep, 15% on that 1/2 most likely.
Okay.
I'm just, throwing that out there. All right, brother.
Okay. That's all I need.
All right, take care.
Thank you. Bye.
540-0580. Carl Rominger here answering your legal questions. Sue, you're on the air. Hi, Sue. Sue?
Did you say Sue?
I said Sue.
Okay, yes, that's me. I have a family member who was in their 40s accident a year ago. It wasn't their fault, but there's a lot of brain damage.
Right.
And his mother, who left the family when he was an infant, went to see him in the hospital. Somehow she got power of attorney, and we understand she has accepted, now she's the in-law, she has accepted $50,000 from the other people's insurance company.
Okay.
Well, he had been earning like $65,000.
Right.
The accident. Now, anything anyone can do or should do since she has already accepted the $50,000?
Well, we don't know if what that $50,000 represents. Was that the policy limit from the insurance company?
I don't know.
And if it's the policy limit, I mean, you can't get more money than the policy limit out of an insurance company. But she may have goofed up by not getting all the policies she could. She may have prejudiced the ability to collect from other policies. Is she using a lawyer?
I assume.
Yeah, so you would hope that if they're using a reputable personal injury attorney, they would be able to figure that out. More importantly, probably a lot of that money doesn't go anywhere but to pay medical bills, right?
Well, probably, yes. But is there any recourse that the family has after, if they'll probably not get better?
Right.
Future income possibility.
Yeah, but I'm trying to tell you is it depends what the limits are. I mean, if you go out and you buy insurance and you don't get uninsured, underinsured for yourself, and the guy that hit you has $15,000 in insurance, even if they break your back and leave you as a quadriplegic, all you're getting is $15,000. Right?
Okay.
I mean, that's you're limited what you can recover from what you can get from the other side.
Okay, that could be possible, but also, if suppose they had $100,000 or $500,000 or whatever, is there any way that we can find out different kinds of power of attorney? Well,
that's what I'm trying to figure out how they got a power. If this guy's that incapacitated, I mean, is he mentally there?
Well, about a 5 or 10-year-old.
So he couldn't have given a power of attorney. It would have to be a guardianship, and a guardianship would take a court action. Otherwise, that power of attorney is going to be a fraud.
Well, that's what we thought maybe too. That since she is not in the family circle.
Are you visiting this person, or who's visiting this person from your family?
Well, mostly nieces, aunts.
Yeah. So I mean, the short answer is, somebody would need to go to the courthouse and see if a guardianship's been put in place. If a guardianship's been put in place, then the court's going to approve any settlement. And if there's lawyers involved, trust me, I do a lot of personal injury work, and I can tell you I try to get as much money as possible for the clients. We try not to leave anything on the table. So if there's a halfway decent lawyer involved, you can assume that they're not going to settle for $50,000 unless that's a reasonable settlement under the circumstance.
Well, it sure doesn't seem reasonable.
Wow, that's what I'm telling you. Most likely, $50,000 sounds like a payoff limit on insurance.
Yeah.
All right, Sue. The other thing you can do is sit down with a lawyer and get some more specifics and get some investigation going, but that's going to cost money.
Right.
All right. Take care.
I thought, maybe you could tell me some words to use.
Well, I don't know who you'd talk to. I mean, you could ask them, but I guess I'd find out if he has a guardian or not. And if he has a guardian, I'd find out who the personal injury attorney is.
Okay.
All right?
First, okay, thank you.
540-0580. Carl Rominger here. I'm going to be broadcasting live from 1000 North Prince Street next week, so you can stop in and join us there in Lancaster. That'll be from 1 to 3 live at 1000 North Prince Street, so put it on your calendar. See you in a minute. Welcome back. Carl Rominger here. I'm going to be filling in for Bob Durgan here on the 27th from 1 to 3, 3 to 6 p.m. here on WHP 580. So if you want to talk politics, we'll talk all things politics. But I'm going to spend some time on Monday on this Muslim judge controversy that's sprung up. And I talked about this last week, and I talked about it on Durgan. And for some reason, everybody thinks that we have a district justice in Cumberland County who's converted to Islam and let some Muslim guy get away with murder. And it's probably untrue on every count. He's a Lutheran. He's not converted to Islam, and nobody got away with murder. And really, it's a bunch of silliness. But the guys who wanted to get some publicity out of it certainly have gotten what they wanted, and it made it to the blaze with our friend Glenn Beck is regularly talking about these things. And I would love to have an opportunity to defend this a little bit more, because I just think it's crazy. I think that if you want to dress up as a zombie pope and a zombie Muhammad and go walking down the street and offend somebody's religion, end up in a tussle that was not a stabbing or a fight or a vicious attack, and there's video of it, but it's a little murky. If the video was better, I think this whole thing would have blown over by now already. 540-0580. Seth, you have a contractor question?
Yeah, I'm a window cleaner and power washing contractor, and basically I'm segueing over from residential to more commercial, like apartment complexes, whatnot, and I'm rewriting my contracts. And I want to be clear in the terms with the client about what actions I'm going to take if they withhold payment for some reason. And so basically, my question is, what legal actions are the appropriate actions to take if a client doesn't pay? Okay. For instance, like a property management company, or even a company that owns like a 3-story building or something like that.
Right. Well, the short answer is, obviously the whole purpose of having a contract is to get a promise to pay. You want to make sure your terms are well defined in the contract as to when payment's expected. Mm-hmm. Also, make it clear that you would seek a attorney's fee damage clause in there that basically says you reserve the right to seek reasonable attorney's fees. Mm-hmm. I have something along the lines that client will pay all court fees or whatnot. Yeah, but that's the term of art would be reasonable attorney's fee. You might want to just look up a clause for reasonable. It's agreed that should there be a legal dispute over this matter, the losing party agrees to pay the reasonable attorney's fees of the breaching party, et cetera, as well as all court costs. That way, you've got that in there, because what you run into sometimes when you talk about dealing with commercial entities. They may consciously make the choice and go, you know what, we don't really feel like paying this guy right now. We're just going to hold off and wait 120 days. So, maybe you also want in there a interest rate as for anything that's over a certain term, what your interest is going to be as well. In other words, from a commercial entity standpoint, they're not going to feel morally obligated to pay you. They need to know that there's financial disincentives to simply stop paying you and wait you out.
Gotcha.
So
go on.
No, go ahead.
What about a mechanic's lien or contractor's lien? Can that be taken into the commercial realm, or how's that work?
I don't. If you're just doing cleaning, I'm not sure if you can get a mechanic's lien. Mm-hmm. That doesn't sound right to me.
What's the premise of mechanic's lien? The
premise of mechanic's lien is that if you come and do something to the real estate that creates a fixture. In other words, if I come and put a roof on your house, I can't just take the roof back. It's become a fixture to the real estate.
Mm-hmm. Okay, gotcha.
And so the idea that that's a concept of mechanic's lien protects me in that regard, because I now have a lien against the real estate that I improved.
Okay. So, in conclusion, basically just make the terms extremely clear, and all fees are on the client.
Yeah, and then also keep this in mind. It's a business decision, but if they're 30 days late paying and you want to go do some more work for them. I had this years ago. A guy was a snowplower, and he plowed snow for a pretty large commercial enterprise who was having financial difficulties, and they'd missed a couple payments to him. And, of course, how snow works. It falls, you got to plow it or else. Mm-hmm. And he says, well, comes in, wants to sue him, et cetera, et cetera. And I say, okay. And I'm like, this is probably going to end your business relationship with them, but we'll send this over. And he's like, oh, I don't want to do that. I still want their work. And I said, well, I understand. So what we did was we approached and went to a cash-only basis going forward, prepay. And that's just a little something you can put in the back of your head, too. If you do have an entity that's falling behind, but you don't want to really lose the job and you think maybe they're going to come back, don't let it keep building. We've had people, they go back 4 months, 5 months, 6 months and reservice an account, don't get paid. Now they're 6 months out and they're never going to get paid, or they're going to have to fight for it and wait, and that hurts their business. So you need to be aggressive on that. But again, sometimes being too aggressive might cost you business that otherwise you could keep.
Right, I got you.
All right?
Yep.
All right, hope that's helpful.
All right,
All right, Seth, thanks. 540-0580. Bill, what's going on?
Hey, about 2 years ago, I got parking tickets from the city of Philadelphia. I've never been in Philadelphia. It went to like over $400 in parking things, and kept writing and got to no avail. So finally went to Mike Fulmer's office here in Lebanon, and they wrote a letter saying, hey, it wasn't there, there's no way it was there, and they cleared it. So about 6 months ago, this starts happening again. I keep getting parking tickets from filled up the same plate from a truck I had about 7 years ago.
Huh.
So I don't understand. I mean, it gets tiring after a while. I have to keep running down to the office and taking time off work to do it. Is there like a civil lawsuit? Anybody do anything in the city of Philadelphia for doing this? I mean, I thought other people get random parking tickets from the city, but I don't understand. And when you call down there, it's like this giant vacuum. You just get sucked into a hole where no one can help you. You get bounced around, and they just say, hey, listen, pay your ticket and suck it up. But like I said, I've never been there, and here I am again going through the same thing I did 2 years ago.
And I've seen these random tickets. Sometimes it's a stolen license plate that somebody's using.
Right.
Other people think that there's just an outright scam, that people just go around and just make up tickets. And that's another possibility as well. It's interesting. It's a truck you haven't had in years, right?
About 7 years now, yeah.
Yeah. So, and is there a lawsuit against them? I wonder about that. I actually just had somebody bring me a Philadelphia red light camera ticket from 4 years ago that they just got in the mail saying that they ran a red light. It does look like their car, they told me, but they're like, it's a little strange that it takes them 4 years to send you something.
Right.
So I guess my thought on the matter is I don't know if there's a great civil remedy, but it'd be worth exploring. And maybe a class action against them for this, but it seems to be a common problem around the state. I've also seen York County doing something similar where they're pulling up old cases from like the 80s and the 90s and telling people they owe a balance on it. And I've had a few people in the area go, well, I paid that off years ago. I know I did.
Right.
But I don't have my checkbook from 1983.
And the most frustrating thing is, like, I've never been in Philly. I think the last time I was in Philly was like 12 years ago to see like a Phillies play.
Right.
That's it. I mean,
Oh, no, and I don't think most people who get these, they were never in Philly. Somehow it's a stolen license plate, works its way back into the city. Somebody makes a fake registration, et cetera, et cetera. There's probably somebody driving around down there on a fake set of papers with a truck that, or maybe even just a car with your plate on it.
Yeah.
So, Bill, I wish I had a better answer because this comes up again and again. But it does seem abusive.
Yeah, it's frustrating because you go through it, you take the time off work to go down to your representative's office, and then by the time it starts costing me on my end because I got to fight something that's not even mine, and yet take off work to do it.
Well, and that's what some of us who think that this is some kind of elaborate scam by the city to make money, or at least some minions in the city to make money, think is most people just give up and send the money in.
Right.
Because it's easier. All right, my friend.
All right, thanks.
All right, thanks. 540-0580. I want to remind you guys I'll be broadcasting live from 1000 North Prince Street next week. That's our Lancaster office, so you're free to stop in from 1 to 3. We're going to have Paul Chase there, who's a short sale specialist. He's a realtor. If you need have any real estate issues whatsoever, we're going to have some realtors there. But if you have an interest in a short sale behind on your mortgage, Paul's going to be there to help you out. Bill, you're on the air.
Hey, Carl Guru. Hey, this subject is on the bicycle law of 4 feet passing them and everything. You know, all these years I haven't had a problem with bicycles. I rode a motorcycle for 50 years, and out on the trail when I'm walking, these bicycles come behind me and they ring their bells to let us know they're coming by, and everything goes good. And I've always just tapped my horn on the highway one time to let them know I'm behind, and I even go over on the double yellow line. But now that there's this law that you have to have 4 feet, I mean, 4 feet, what? Do we go over on the yellow line, or do we not pass them, give them 4 feet, or what?
I used to ride my bicycle around quite a bit in Cumberland County. Haven't done it in a few years, but I used to ride around on these rural roads where there wasn't much shoulder, and these cars would go by you, and they would give you a big berth. And I always used to worry about that. I always preferred the car stay closer to me than give me too big of a berth, particularly because people would do it on curves and places where the road wasn't very tight, and they would be 3 feet into the opposing lane. And my theory on that was that when some yahoo is giving me a 12-foot berth and moving over into another lane, when the car comes whipping around the corner from the other direction, I'm going to be there when they collide.
Right.
So I'm not sure. Encouraging people to take too big of a berth is. I think the answer is you just have to use your common sense. And if you want to ride your bicycle on a narrow road, be prepared to have cars close to you. And if you want to ride your bicycle on a big, wide open stretch of road and there's lots of room, then I don't think the car should be encroaching on you. But I don't think a driver in a car should have to risk his or her life to stick their wheels over across a double yellow line. And since you're supposed to give the bicyclist 4 feet, remember, however, that the double yellow line isn't in of itself illegal to cross, right? It just marks a no passing zone.
I don't know.
Yeah, I mean, so in that regard, you could certainly put your wheels over it if it was safe. And I think that's the thing. You got to be prudent under the circumstances. And I would gladly argue to a judge that I only gave the bicyclist 3.5 feet because I wanted to give the other car 6 inches.
Yeah. You want another one or not?
I got to go to break, brother.
Thanks a lot.
All right, take care.
Bye.
540-0580. Hey, welcome back. 540-0580. Oh, just having too much fun here. Well, I'll be floating for Durgan on Monday, so 3 to 6. Actually, Bob was actually floating around the studios when I got here. And, yes, he still wears his cowboy hat even when he's not broadcasting. So it's not just a prop. And JC's over here floating around, too. So the whole crew's here. Shane's here. I mean, it's crazy. Anyhow, 540-0580. Jeff, you have a will question.
Yeah. Hi, Carl. I was calling about probating a will. Do I need to have a CPA do the financial things and a lawyer probate the will? And is there like a paper that I could use to follow or a book or something like that? It could be extensive.
The short answer is maybe, and maybe. On simple estates, okay? In simple estates, the lawyers a lot of times take care of all the housekeeping. If the estate has a more complex tax nature or ongoing income, etc., a lot of times we tap a CPA and bring them in. So if that answers your question, now to follow along, following along, there's some basic stuff out there. There's a book that we use sometimes, but the reality is if it's a complex issue, there's going to be no how-to guide, and that's, of course, why you end up using the lawyer and the CPA.
So do I talk to the CPA first or the lawyer first?
I would usually talk to the lawyer first because the lawyer's the one who's got to get everything rocking and rolling, so to speak. And then the CPA would be the second person because they're going to be the ones, once the estate's open, that the person who is handling it, the executor, executrix, or administrator, or administratrix, is going to interface with.
Okay. Thank you very much for your help.
All right, good luck.
Bye-bye.
Oh, boy, oh, boy, oh, boy. Dave, you're on the air. David.
Good afternoon. How are you, sir?
Good. How are you?
I'm sick as a dog, but that's all right.
Don't sneeze on your phone. I don't want to catch it.
Okay, I promise I won't. Listen, I was sued by a major credit card company, and I went into district court, and it was for they alleged $5,400. The district justice heard the terms of the contract that I had sold the debt to somebody else. I paid somebody to take it, and I had a notarized statement that this other company took it. Okay, well, they lost it in a heartbeat at the district justice level. They have since appealed it into the Commonwealth Court here in Lancaster, and they've charged the same thing. And my attorney and I sent interrogatories to them requesting the check stubs for the past back to 2007. Okay, now the time limit on the interrogatories, I believe, is 20 days, and that was up 4 days ago. They did not answer the interrogatory. They instead sent big bank statements that they had from the credit card company and the fine print, which you can't read, and a letter stating, here's the information that the plaintiff will use in arbitration. Well, I never asked for arbitration. I asked for a trial, and also in the provision that my attorney found, there's a thing in there that I could countersue them, and I did countersue them for $50,000. How can they transfer that from a court trial to arbitration without me even knowing it?
Well, the total amount in controversy has to be above the arbitration limit, or else you have to go to arbitration. In other words, it's called
$5,400.
What's that?
$5,400.
Yeah, Pennsylvania has compulsory arbitration for all civil suits where the amount in controversy is under a certain amount. And so, for instance, in Cumberland County, the arbitration limit's $50,000. Any amount in controversy under $50,000 has to be arbitrated before you have the right to a jury trial.
Okay. So if I lose the arbitration hearing, then I can still appeal that into the county court again for a trial.
Correct.
All right. Now, since we asked for the interrogatories, they never sent the interrogatories, and the 30 days for them to answer the complaint of the $50,000 against them is due next week. So if they don't answer that,
Well, if they don't send in answers to interrogatories or other discovery, then your lawyer can file a motion to compel. If they don't answer a counterclaim, you can attempt to default them by sending them a notice of intent to enter a default. Once that notice of default has passed, which is a 10-day notice, then you can default them, and then there's just a trial on damages.
Okay, I got you. I understand that. I didn't know that about the arbitration.
Compulsory arbitration. Yeah, I don't know what Lancaster County's limits are, but they're probably similar to Cumberland County's, $50,000 or $70,000.
Okay. But they never answered the interrogatories either. But we can file
a motion to compel.
Yeah. But the motion to compel is going to cook them, because when we originally got the complaint, an attorney signed it, and my attorney said there's no way he can swear to that. And so that's where it goes back and forth. And you've given me some good information here. I didn't know. Thank you.
All right. Good luck.
Thanks. I'll need it.
Right, no problem. I'll need it. Yeah. 540-0580. Rachel, you're on the air.
Hi.
Yep. What's going on?
Okay, so my husband and I live in a first-floor condo. The unit above us, their water heater leaked down into our water heater closet, causing damage on our side. We filed a claim with our insurance company, and so did the landlord above us. We happen to have the same insurance company. We're ending up paying the claim because the insurance company says that they don't find the landlord above us liable, even though it was their water heater. So what we want to know is, would there be any benefit for us to take the owner upstairs to small claims court to recoup our deductible, or do you think the court would rule the same way as the insurance company?
Well, that's an interesting question. There's no reason to believe that one would rule the same way as the other. I mean, that's internal to the insurance company. We used to joke that the internal arbitrations at the insurance company, they just kind of look whose file's thicker. So I don't know the answer to that. But the deductible's how much? Probably like $500?
Yeah. So
you could just sue the person at district justice court. That would be your most likely and easiest venue.
Not small claims court?
Yeah, that's what I mean. District judge is small claims in Pennsylvania.
Okay. And is there anything, I know that's without a lawyer, so is there anything else that we need to go in there prepared with? And we have lots of evidence.
Just take your evidence and present your story, and hopefully the judge goes your way.
Okay. All right. Okay, thanks.
All right.
Yep.
I know well, here's the answer. You don't want to spend a lot of time on it because for $500, if you hired a lawyer and put everything together, it would be more expensive than you're going to recoup.
Yeah, and would there be any benefit, for us trying to find some kind of negligence or pain and suffering, adding that in?
The short answer is, if you actually have, if you can prove it, and if you have pain and suffering, unfortunately nobody got hurt, right?
No.
So we don't have pain and suffering when nobody gets hurt in the law.
Right.
Despite what everybody thinks about these crazy lawsuits and thinks that everybody's out there just milking the system, you can't get pain and suffering unless somebody actually sustains a physical injury.
Right.
Or occasionally a mental or emotional injury, but that requires special proof.
Okay.
All right?
Okay, thanks.
Good luck.
Yep.
I don't know if that's a great answer, but I think it's adequate. Just get your stuff together, go in there, and have fun. Mary, what do you got for me, Mary?
When you sign a loan for your child, what does that exactly mean? Like if he's making the payments, then all of a sudden he's not making the payments anymore. Does that go on my credit record as well as his?
You co-signed a loan for somebody?
Yeah.
Yeah. You are as responsible for the loan as they are, and the minute they miss a payment, you're responsible for the payment. And if you don't pay it and they don't pay it, then it goes on both your credit reports.
So I'm stuck with this, until the car is paid off.
Mm-hmm. Mm-hmm. Which is why co-signing a loan is a advisable idea only if you do it with the notion in your head that if the other side stops paying, it's your loan. I mean, why do you?
Not a good thing.
I always like to say, why did you think they wanted you to sign it? What did you think you were guaranteeing? That it would get paid, right?
Well, yeah, but I didn't think that it would go on my report because I have never had anything on my credit report.
Right, but that's my point. That's why you sign it, because you agree to pay it if he doesn't. So you guys say, hey, I like this guy. I vouch for him, right?
Mm-hmm.
That's what you basically said. I vouch for him. In fact, I vouch for him so much that if he stops paying, I'll pay. So, Mary, let's just remind everybody out there, when somebody asks you to co-sign something, I don't think people, and I'm beating up on you only a little bit because I don't think people are clear on this.
No, you're not.
Co-signing a loan is like getting a loan. The only difference is when you're a co-signer, you're not the first person who has to pay it, but you're just as responsible as the first person when they don't pay it.
Well, okay.
So, there you go. Protect your credit. The other thing you can do, you can make the payments and sue the other person to protect your credit. That's been done.
Yeah, but if it's your son,
yeah, well,
I kind of hate to do that.
Well, he doesn't seem to mind doing this to you.
Yeah. Okay.
Yeah, that's what kids are for.
Yeah.
All right.
Thank you.
Good luck. Yeah, the deadbeat. 540-0580. I'll see you guys after the break. Welcome back. Carl Rominger here. I was just realizing that zombies seem to be all over the central Pennsylvania court system right now. We've got the Muslim zombie attacked, Muhammad attacked with the district justice, and then Durgan had me on a little bit ago for the woman who dressed up as a zombie to protest Black Friday and was acquitted. So I guess the zombies are having various results in court locally. Interesting how that happens. Joanne, you're on the air. Joanne.
Joan. Camp Hill?
Yes.
Okay. Hi. Yes.
What's going on?
Am I speaking with Carl?
This is Carl. You're live on the air, so be careful what you say.
Wow. Okay. Say, this quotations about lawyers, I always think they're funny quotations about anybody. It comes from sources, the Bible even. I'm sure you know these things. I came across a really cute one here that I wanted to read to you.
Go ahead.
And do as adversaries do in law. Strive mightily, but eat and drink as friends. You know that. That's Shakespeare. You know that. And wouldn't you think it was from Taming of the from Merchants of Venice?
I've actually heard the saying, and actually, it's probably true. Somebody said to me one time, "Oh, you guys know each other, and you all work it out, and you don't want to buy." I was like, "No, you don't get it. I'd rather
go
be
to the gym even together to work if you have to."
Yeah, I said I'd rather. I get a lot of business done in the locker room, but I said I would rather beat up on somebody I know because then later I get to rub it in their face.
Maybe shame on you, but haven't you seen even in the movies how later on they meet at the end of a whole big sweaty trial, and people are all filing out of the courthouse and stuff, and they meet sometimes.
Oh yeah.
Speak or they glance at each other. They have a drink together.
Yeah, and I actually you figure this out when you're a kid if you just watch the cartoons, right?
Exactly.
The sheepdog and the coyote.
Yeah, strive mightily, but eat and drink as friends.
Well, thank you very much. I appreciate that.
So you remember at the end of trials at Nuremberg, Spencer Tracy didn't want anything to do with anybody.
Yeah.
Do you remember that flick?
Yeah. Oh, yeah.
That's a great one.
Yeah.
Hey, good luck in your career slot.
Thank you very much.
It's coming along, isn't it?
Well, I don't know.
You're going to be national, Carl.
I don't know about that.
Okay.
Although I think I was quoted in the Wall Street Journal today, so I'll take some credit, I guess.
Okay, thanks.
All right, take care.
Bye-bye.
Yeah, and Rush Limbaugh made fun of me. That's exactly what I was planning. Hey, Mom, guess what? Rush Limbaugh made fun of me. Bill, you're on the air.
Oh, guru. I came back again. Hey, do you know the name of a good lawyer? It's just a joke.
Well, I always like to say they're all in Harrisburg, but that's because my office is in Carlisle. But now I have an office in Harrisburg, so I had to change my joke.
Hey, listen, theoretically, I'm driving down the road in my car, and I'm speeding a little bit. I get pulled over, and then the cop comes up. He says, license and registration. I hand that to him. Then he goes back to the car, and he says, okay, get out of your car. I have to get out of the car, right? And then also, while I'm out of the car, he says, you don't mind if I look in your car. Now, do I say, sir, I know you're doing a job, but I don't consent to a search, or where do I go from there?
Yes, he can get you out of your car. You're correct about that. Under Pennsylvania law, passengers and federal law, passengers and driver can be asked out of the car for, quote, officer safety reasons. However, the search of your car can only be done with your consent or with a warrant.
So which way do I want to go? I mean,
well, I'll put it to you this way. If you don't have anything illegal in your car, I guess you could let the government search it. On the other hand, you might not know if you have anything illegal in your car.
Right.
And that's the problem. So once you give them consent, then they're free to search your car. On the other hand, if you make them get a warrant, then they have to have probable cause and convince a judge that they have adequate probable cause. And my favorite is the one where the cop says, well, I'm just going to get a warrant. Well, you're better off to make them get the warrant because that can be tested. In other words, another judge later will say, no, they did or didn't have the ability to get the warrant, and then you can win on that basis. Consent, most of the time, is going to carry the day, and you're not going to be able to complain about a search of your car. I had a client who had 7 pounds of marijuana in the trunk of his car, and when the police asked him if he could search the car, he said, yes, you can search the car, but you can't look in the trunk. And the police went nuts, and an hour and a half later, he ended up consenting to a search, but that consent was found to be tainted because of the illegal detention of him for an hour and a half, because he was perfectly within his rights to tell the police they could search some areas but not others. But as you can imagine, that aroused their suspicion mightily.
Okay, now, one was out on the street. I mean, not a street walker woman, but just a woman out on the street. She's sitting there waiting for a bus or something, and the cops come up, and they suspect her, and it's not really her problem, but they think she's, misidentified and all that. So they pat her down. They don't feel anything. Then they want to look in her purse. Does the same thing apply there?
No, she doesn't have to let them look in the purse. I mean, okay. And you can circumscribe the scope of the consent. So, yeah. I would never let the police search my car. I would never let the police search my purse. I would never let the police search anything of mine, ever. There's a guy in jail because he didn't realize that shipping lobsters in plastic bags was illegal. They had to be shipped in paper bags instead. So when you start thinking about what the crimes can or would be.
Yeah, thanks a lot.
All right, Bill. Do I need to go to break? No, I don't need a break right now. I'm good. Okay. We're going to a hard break here in a little bit. Norm, you're on the air. Norm.
Yes. Hi, Carl.
Hey, what's going on?
Well, there's two things. One is real simple, and that is I've been trying to get your free will downloaded, and I keep getting this crazy message. I don't know if I tried to download it once, and I didn't do it, and now it won't let me, and I wonder if there's some other way to get it.
If you call the office, they'll email you the kit as well.
Okay, great.
So anybody out there who's listening, if you're having trouble getting the kit for some reason, or you don't have the internet, just call the office, 241-6070, 717-241-6070. Tell me you want the free will kit, and they will mail it out to you or email you the direct link to it.
Okay, great. But that's not the main reason I called.
Gotcha.
I was with Verizon, and back in October, I changed to Comcast. And I canceled my services, and I had no problem doing all that. And since October, I've been getting a credit bill that they owe me money of over $300. Over and over and over again, I just keep getting the bill. I keep calling them, and they keep telling me, blah, blah, blah. It takes time. It'll all work out. Come a couple of weeks ago, I got what I assumed was a final bill, which was again for the credit of over $300, and then they sent me a bill that I owe them $80. The bill for $80, they say if I don't pay in 10 days, they're going to put it in collection, which I doubt. It's the first time I got that bill, but the $350 they've been playing with since October.
Okay.
and I haven't had their services since then. What rights do I have? You can't talk with these people; they're so big.
No, the answer is you might want to just. I don't know what the right answer is. I guess you could sue them in district justice court. That might get their attention because it'll take it out of the normal process and take it to the legal department. And maybe somebody will be able to cancel it or give you your refund.
Is that what small claims is? Is that the same thing?
Yeah, you did local district judge. And then just get it served on him. If nothing else, you get a judgment against him and then execute it.
It's Verizon.
Yeah. Norm versus Verizon.
That would be something. So I remember many, many years ago, I heard some show, probably before you were born, maybe, that if you're in the right and a company does something against you and you don't deserve it, and you have good credit, which I really do, that you can actually sue them for that. For
ruining your credit. Yeah, you may be able to sue them for that. The Fair Debt Collection Practices Act maybe also be implicated. All right, my friend, I got to go.
Okay, thanks.
Mark and Dan, hold on, guys. I want to talk to you guys after the break here. We'll be on for another hour from 2 to 3, still answering your legal questions live. Carl Rominger here. Go to weekendappointment.com to get that free will kit, or go to romingerlaw.com to learn more about us or hire us. See you in a few minutes.